Good morning, it's lovely to have you with us. Welcome to our talk here at Cripps in partnership with Bespoke. We're glad that you spent the time with us this morning, and we're going to cover some of the employment changes. As many of you will have seen, there's a lot in the press, so we're going to do some myth busting and we're going to look at some horizon scanning for what you need to do in your business. A little word about Cripps to start. We're lawyers for businesses and for individuals. So we do a lot of work with businesses, particularly in the architectural space, and we do a lot of work to help them on all areas. So that could be dealing with matters of real estate or, in my case, employment law. So helping you navigate when you get those difficult questions from people in your businesses. Looking at where we are today, I think I would say that Cripps has got 3 offices, Tunbridge Wells, Horsham, London, and what we're doing is building our relationships, partnering with our clients to help them grow, help them to move forward. So if you have any questions on other areas and I can't help you with that, I will find you someone who can. So please don't hesitate to reach out. We do a newsletter which is absolutely complimentary on employment law. Very much like to invite any of you who aren't already our clients, and I know some of them are in the room, but if you're not, please do give me your email address. I'll add you to the list. We'd be delighted to invite you to seminars like this or webinars that we do, and if they're of interest, you can build on today. So, what are we going to go through? First of all, we're going to look at the 2 new main laws that have come into being. Employment Rights Bill will become the Employment Rights Act, so that's where we're going from it. Then we're going to look at 2 particular topics where we're going to go into a little deeper dive on what does the legislation mean and what do we have to do. These are where we're getting the most questions at the moment from our clients. So we're going to look at sexual harassment and prevention, and we're going to look at flexible working requests. So starting with the new legislation, I think the key thing here is that there has been so much in the press that I think we've lost what the legislation actually means. So I want to bust the myths. I want to give you some information that will enable you to think, okay, we need to do this now, but we can do this later in the year or in 2025, 26. Let's look at what the Employment Rights Bill really means. Has everybody seen the press where it says there's going to be a day 1 right to unfair dismissal? I think there's unanimous nodding of heads. Absolute myth. What the legislation says is after an initial period, employees will have a right to bring a claim for unfair dismissal. So what we're anticipating, and the government has said it will not be before autumn 2025, is that there will be a change in the law. At the moment, an employee has to have 2 years' service, usually, to claim unfair dismissal. There are some exceptions, whistleblowers, pregnancy-related, being 2. But what will happen is that they're going to bring down the qualifying period. But they're not doing it yet. It's not in force, and it may not be in force in autumn 2025. We'll have to see. What is the length of the probationary period or the initial period before this kicks in? The government's consulting on that. They've said that it could be 6 months, it could be 9 months. So in terms of trying out a new hire, you will still have that 6 or 9 month period in which to check whether they meet the requirements of their job role. If we think about that logically, we now have to say to ourselves, okay, we're going to have a shorter period to test someone out. So what do we need to do? Can we be more rigorous in our hiring process? Can we think more carefully about the job profile? Are we able to think with managers about what they're putting in those one-to-one and catch-up emails and appraisals so that at the end of that period, we're able to say you've met or you haven't met the criteria? I talked to Mina earlier and we were just talking about the differences between the US and the UK. And, you know, my perception is that the US is easier. And I don't know if it really is now, because I'm thinking that there you have to be much more robust that you're not doing it for unlawful reasons than we do. I think that in the UK, we're still going to have that obligation to show it's not discriminatory. It's not because they asked for flexible working. It's genuinely because they didn't meet the quality required. Looking at periods to bring a tribunal claim. Normally now, an employee can bring a tribunal claim within 3 months of the act that they're worried about. So if you sacked me, I could bring claim within 3 months, and you'd know probably within 4 or 5 if you're lucky, although I have, with somebody in this room, had somewhere where the tribunal forgot to issue the claim at all. So it happens. The tribunal is going to give people longer time to put in that claim. They're going to give them 6 months. This is not in law yet, and I don't know if the tribunal can cope if it does. So the government is consulting about whether to do it. So it may never happen. But the reality is that employees who leave you could bring claims anyway. What's going to happen now is you might have a claim that arrives later than previously you thought. So it's almost about managing your stakeholders. We can't say for certain that there isn't a claim yet. Okay, so minimum wage. Who's read that they're going to equalise the minimum wage for everybody? Yes, over time. That's the Labour intention, but not yet. What we know is that from the 1st of April 2025, the national living wage for adults, so workers over 21, is going up from £11.44 to £12.21. Those of you who've been doing your salary projections, this is probably old news, but it's a 6.7% hike. They're closing the gap for the 18 to 20-year-olds. So from April, that rate goes from £8.60 an hour up to £10 an hour, which is a 16.3% increase. So we're not yet seeing an equalisation of minimum wage. What we're seeing is that they're trying to move it up without causing businesses concerns. And I'm saying this because I'm talking about the employment law aspect, but you've still got the national insurance aspect on top. So that's a change. Let's think about sick pay. There is absolutely going to be a right to greater sick pay. So normally, at the present, you have to wait for your 3 days and then you qualify for statutory sick pay from day 4 onwards. This is not what you've put in your contracts. You might have put will pay 5 days, 10 days a year. So that's a different thing, your contractual position. But under law, you have to pay from day 4 of continuous absence. You only pay if somebody hits the lower earnings limit, and that lower earnings limit is coming away, which means if you've got part-timers who go sick, they're more likely now in future to qualify for statutory sick pay. Statutory sick pay itself is going to be more available, and some of the commentary suggests that that might make employees more inclined to go sick. Perhaps that might increase a little bit your costs. So you might want to think carefully about how you're going to manage sickness absences in the short term. And if you've got particular trigger points for actions to be taken, occupational health referrals, that sort of thing, you might want to be reviewing those. 0 hours contracts. The government has long said they want to ban them, but apparently they only want to ban the exploitative ones. They've now rolled back from banning them entirely. So if you use 0 hours contracts in your businesses, you might want to think, okay, do we think that this is genuinely what hours we're going to ask this person to work? Do we want to give them a contractual obligation that we will pay them 1 hour every month? Because then it's not exploitative 0 hours contract anymore. Do we want to think about how we're engaging with people? Do we want them to be employees or workers? Or do we, as a lot of us have been discussing this morning, want to think about genuine freelancers who are sole traders? So there's lots of options on this one. We know that there are going to be changes on contracts so that they reflect the number of hours regularly worked. The intention is that they will give workers reasonable notice of changes of shift or of hours and appropriate compensation for shifts that are cancelled or curtailed. I was on one of the government consultation discussions, and there was a very firm feeling that the government, notwithstanding all the commentary and opinion voiced by business, is going to pursue this. So if you have got contracts where are not reflective of hours, this is definitely one that you need to look at. The government is not changing its mind, and it's not open to revision on this one. So this is definitely something that it's not in force yet, but it is something that I think in 2025 we'll expect legislation on. Okay, banning fire and rehire. We don't always call it fire and rehire. We tend to call it dismissal and re-engagement. So you offer one lot of terms, they say no, we offer a new set of terms. The government is telling us that this must be a last resort. Employers will have to contact ACAS and tell them their intentions before they can start having conversations with their staff. And in those consultations with your staff, you know that if you're potentially doing redundancies, you have to consult and you have to talk to their employee representatives. So this is going to mean that some of your processes are going to get a lot longer. When we're looking at banning fire and rehire, as you will probably know, you already have, from October last year, a statutory code that you have to follow if you're looking to dismiss someone and re-engage them on new terms. So this is a situation where you have got to think ahead in your business planning, and with the best will in the world, I think you've got to get your management team to be thinking ahead on their business planning, because it's not going to be the case that you can achieve headcount counts as quickly once legislation changes. Flexible working, I'm going to cover that in more depth later, but I just wanted to put it on the slide so you remember where it fits. When we're looking at parental leave, we're going to have many different kinds of leave changes. So we're getting much more family friendly here. We're going to have unpaid carers leave, care for a dependent who's got a physical, mental illness or injury, needing care for more than 3 months. So that's a new law. We've got new neonatal leave that's already come into force, where we've got legislation that will give up to 12 weeks of paid leave as a day one right. That's where the individual has a child who's in, or a baby, sorry, who's in hospital for up to 28 days or has a stay of 7 or more days. And then we've got paternity leave. We're going to remove the 26 weeks continuous service for a bereaved parent or individual. And we're going to have parental leave, removing the 1 year qualifying period. So what this means is if in your handbooks, your policies, you've got on your website all of these qualifying trigger points, we're going to have to, once the legislation comes in, change all of those, reduce the qualifying periods, and think, right, more of our staff will be eligible to use this right. How do we factor that into our planning? Sorry, I've touched on bereavement leave out of order. I'm so sorry about that. And I'm going to go into preventing sexual harassment later. So let's look at redundancy consultation. Making up to 19 people redundant isn't a problem. You follow your normal fair process and that's what you do. What we're talking about here is redundancy consultation when you're doing larger numbers. So it's 20 or more in a 90-day period. So normally at the moment, you would have to consult with the employee representatives of those staff for 30 days before you can give the first notice letter. The government is consulting to increase the maximum period when that consultation has to take place. They're saying we either increase it from 45 days to 90 days, or we remove the cap entirely. And the import for this is that if you failed to do the right period of consultation, the employee can go to the tribunal, say they didn't consult with me, and get a protective award. And the protective award could be that 45 days or the period up to 90 days, or it could be an uncapped amount depending on the degree of fault on the employer's side. And this is actual days pay. It's not capped days pay that we're usually dealing with. So this is quite costly. And again, it is putting the onus on businesses to really plan in advance and think what they're doing before they go into redundancy processes. I'm going to come on to equality action plans in a second, but I think we're also going to see protection for outsourced workers. The intention is that they're going to try and bring agency staff and any workers that are working through third-party bodies to have the same rights as workers and employees who are employed directly. We are awaiting further information on this, but I think the key messaging is we've got to think carefully about our population. Who do we work with? What status do they have? And how can we make sure that we're in the best position so that we're compliant going forwards? So how can you prepare? Well, I think auditing your contracts and your people, as I've just said, think about how you distinguish between your staff. Many of you will have people that are within IR35, so you put them on your payroll, but you don't necessarily regard them as employees with all the rights that employees have. Remember, employees have the right to claim unfair dismissal. Workers don't. Employees have the right to request flexible working. Workers don't. Workers have the right to paid holiday, minimum wage. They have the right to potentially sick pay. But there are different categories that have different rights, and you always want to follow that through because that affects your costs. We've talked about 0 hours contracts, self-employed contractors. There is a lot of commentary that there will be a move towards self-employed contractors. I think it's very common in what you do anyway. You will have freelancers. And we were talking earlier, I can't remember the lady we were just talking about. Yes, we were just talking about how do you make sure they genuinely are self-employed contractors? Then you need to be thinking, right, can I satisfy the CES tools if I go through it? I have a checklist. If any of you don't have it because you can't get through, I'm told, on the HMRC list, unless the person's, you click the box to say, yes, they're a limited company. I have a list, so if you'd like that, please contact me. I'll happily provide it. If you think about that, you're trying to make sure that this person is distinguishable. So you don't invite them to the Christmas party, or the firms do. You don't give them pension rights. You don't do other things. You're trying to distinguish between your different populations and follow that through in practice. Because we know from the Uber decision that if it looks like a duck and it quacks like a duck, it's probably a duck. I.e., if you treat them the same as the employees, they will get the rights of employees. They will cost you what an employee costs. Let's think about contracts. We've talked about probationary periods. Obviously, we've got to be live to when that is going to change. But you want to make sure all your contracts have a probationary period. Because otherwise, that individual is going to say, well, I didn't have a probationary period. What happens now? National insurance is going to change in April. We know that. So can you use salary sacrifice? Can you get your staff salary sacrificing into pension so that it's not salary that's going to be incurring a national insurance charge for the employer or for the employee? It wins. Family leaves are going to change, so we need to be looking at our policies. They're not changing yet, so this one's something to look at. And guaranteed hours, I've talked about that one. Payroll processes. Now, this is really interesting. I don't know how many of you actually ask people to confirm their ethnicity and whether they have a disability. Does anybody do that? You do? Okay, that's great. I don't think many businesses do it. And why it's so important is that the new bill, the race and disability bill, is going to start making changes in this area. But if you don't already ask staff, it's something you might need to think about if you're a larger business. I'm not saying everybody needs to get this. And it's very difficult because often it's quite a sensitive issue. How do you ask somebody? You know, if they want to volunteer it, fine. But how do you collect the data in a way? Minimum wage we've talked about. Sick pay we've talked about. Recruitment. That's your business. All I'm saying is be careful. Be more discerning if you can. Get your line managers to really understand the implications because it is going to get a little harder to dismiss. Okay, so we're talking about the second piece of legislation that we anticipate. Again, this is not all in force yet. So we will get in the Equality, Race and Disability Bill a right to full equal pay for disabled people and people of ethnic minorities. So in theory, the Equality Act of 2010, which is already the discrimination law, should be giving this. The intention, states the government, is to extend those rights. So just as at the moment, you have to treat people equally if they're a man or a woman, the intention is that we will have that across the board. For organisations that employ more than 250 people, so it's quite a high business, quite a high number of staff, there will be mandatory ethnicity and disability pay gap reporting, similar to gender pay gap reporting. You can report on that if you have the data that says if somebody has a particular ethnicity, so that you can then carve into groups. If you have a particular data about the particular disability, so you can carve into groups and do that comparison. The difficulty is if we haven't got that data in the first place. Currently, the law says that there must be equality for gender, for maternity and for pensions. And what we expect is that the new legislation is going to say the same. So we're going to have equality for disability, for ethnicity, for pensions and for maternity. So what can you do now? I think really think about auditing pay levels, making sure you haven't got existing inequalities, and then making sure that you record as much as you can get from the individuals in a safe, secure, data protection compliant way, what their ethnicity and any disability are. We also need to think about equality action plans. Now, the government has recently announced that they are going to increase what these gender equality action plans were. It's not just going to be about gender or sex. It's now going to be extended and it will cover menstrual problems and menstrual disorders. I think that was pretty implicit, but now they've made it explicit. Again, equality action plans are only for staff, employers with staff of over 250 people. So it's not necessarily going to affect every business. But as you are growing, as you are combining, if you merge, these are the sorts of things that are going to come up. Okay. Any questions so far?
Is there any risk of changes to Day 1 employment rights in the UK before the final decision in August 2025?
I think unfair dismissal is definitely delayed till past August 2025. I think what we're going to get is a drip feed of regulations that will fit. So we know, or we will possibly know in May, when the sick pay change will happen. And I think we've just got to keep live, because I think those things will incrementally happen as they get the legislation right.
If we hire someone in May 2025, will they still have 2 years of protection under current dismissal laws, given the final decision on Day 1 rights isn't until August?
No, I think what will happen is if you hire somebody in May, the law changes in August. It'll be from August onwards, once that person hits, 9 months or whatever the initial period is. At that point, they will have that unfair dismissal right. And in the 9-month period, what you will need to do is a light touch. This is the legislation calling it a light touch period. So we have to do a light touch process during that period. So I think once the law changes, that will be effective for all. But at that point, your May starter will have completed, part of their probation. The law will apply to them. Yeah.
Are you confident the 9-month cap on probationary periods will remain, meaning contracts specifying up to 12 months would be against legislation?
Yeah, no, I think we're fairly confident it's going to be 9 months. That's what we've seen in the latest government consultation. What I would do in your contract, I wouldn't tie it to a timeline. I would tie it to the statutory period, which we reserve the right to renew, because then you don't have to reissue new contracts and you're compliant. It just means that what you thought you might have, the period you thought you might have, might then decrease.
If our probation period is currently set at 3 months, would you recommend amending our contracts to align with the 9-month cap?
I absolutely would, yes, because that will give you a longer time to test the individual out, yeah.
What is the current legal maximum for probation periods in the UK?
There isn't one. There isn't one, which is why we put them in contracts.
Am I obligated to restore annual leave to employees who fall sick during their leave, even if they're receiving full sick pay that far exceeds statutory sick pay, meaning they haven't suffered any financial detriment?
Yeah, I think depending on what your contracts say, you are obliged. You are obliged to do that. That might be something you look at. Can I just mention a couple of things that aren't in the legislation? There was no right to disconnect. There was no right to bring collective grievances. There is going to be consultation about how we surveil staff in the workplace, although we've already got the codes from the Information Commissioner on that. And we have got the repeal of the Strike Minimum Service Levels Act, which if you saw me on the news talking about, I could tell that nobody was really that interested in the first place. So there we go. All right, sexual harassment. I want to talk about this in more depth because of the law that changed in October last year. So this is already law. Why is this important? Because there is a perception that it only applies between people of different sexes. Doesn't. You don't have to be the direct victim to report it and have your expectation that your employer is going to do something about it. And left unchallenged, the statistics show that this behaviour escalates. So you have more than half of women in the UK who've had a particular experience of sexual harassment at work. Women are disproportionately more likely to experience sexual harassment than men, and nearly a quarter of women have experienced unwanted touching, such as on their hand, their knee, their lower back, as well as unwanted kissing, sexual touching at work. Having done a number of these investigations, this is not the sort of area that you want your staff to be conducting themselves, and we don't want anybody to be the victim of them. So what can we do about it? Well, since 26th of October, we have had the obligation to take reasonable steps to prevent sexual harassment in the workplace. Sexual harassment is prohibited under the Equality Act of 2010, the one that we've already know about. It's the discrimination law. But what you have to do at the moment is anticipate the risks and take steps to modify them. It's only requiring, and I use the word only for a reason, only requiring reasonable steps to be taken. What's reasonable is going to depend on the size of your business, your resources, the sectors in which you're operating, the history that has happened. It's going to be very much fact dependent. And what is reasonable at the moment is that you look at reasonable steps to prevent harassment by other people, but it's what's reasonable that you can do. The difficulty is that this is anticipating. How do you blue sky what could potentially happen? You can look back. Have we had any past experiences? In what circumstances? What could we do to change it different, make it different next time? But you also need to be thinking almost like a health and safety risk assessment. What about when we do blank? And I'm going to come into some events and offsites that might raise some issues. Where the Employment Tribunal finds now that an employer has breached the duty, they can take an award and increase it by up to 25%. Discrimination claims already have no cap. So this is going to get more expensive. Or, to put it another way, to the people who are your stakeholders, if we manage this, I can save you an award plus 25%. So the cost of getting Cripps to come and do some training for us pales. The important reason for the claims is that the highest claim in the Employment Tribunal last year was sex discrimination. So if you're looking at reasons to justify the programme that you're putting in, this is your slide. This is not about a tick box exercise. You know, we've just told people about behaviours and expected. This is not just unconscious bias training that we do at our desks. We have got to do more to prevent sexual harassment. So sexual harassment, what is it? I've highlighted some of the key words. Engaging in unwanted conduct of a sexual nature, which has the purpose of effect of violating a victim's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for their victims. It's also harassment if you treat someone less favourably than you would have treated them for rejecting or submitting to the conduct. So, unwanted conduct, unwanted by the victim, obviously. Okay. Purpose or effect of violating. Intention is irrelevant. What the perpetrator intended is absolutely irrelevant. It's how that person received that behaviour. And what usually happens is that there is a miscommunication or a perception that something is consensual when it's not. Anything that's intimidating, hostile, degrading, humiliating, I mean, these are very wide categories. Anything from the brush pass to the grope, to the images on the computer, to asking somebody to do something inappropriate. I mean, there's a huge gamut here. You have got 6 generations in the workplace, and you have got 6 generations that have grown up with very different attitudes. So how do we prevent it? At the very minimum, we talked about this, have a sexual harassment policy. Don't lumber this in with your other policies. Make sure that you have got this specifically. Make sure that you are showing that you are engaging with staff, setting the parameters. Do your risk assessment. I hate this in a way because I'm giving you homework, and I know that, I'm sorry. But you will be helping your businesses no end if you are assessing the risks and if you are continually assessing the risks. So memo to self, email to office manager, whatever you do, you have thought about what we can do. We have recirculated details of our code of conduct. We've alerted people to how to complain. So we're thinking about reporting. Have we signalled clearly who people report to, alternatives to report to, people they feel comfortable? Do make sure that you are training. Training has to be at least annual. We've got a recent case on discrimination where the employer said, well, we've taken reasonable steps. We did training on this 2 years ago. Employment Tribunal said not enough. So you're not going to give yourself that defence that we took reasonable steps unless you're training annually. Obviously, keep records of everything that you're doing. Take action if you do get complaints. And third-party harassment, we're going to talk about in a sec. Monitor and evaluate. It's great to do the risk assessments. That is the brilliant thing to do. But you need to keep doing them. We need to keep doing them. We need to refresh them. We need to anticipate this new thing that we're doing or this new way of working. Particular areas that they talk about are, do you have people that end up working late at night? We all do. How have we risk assessed the fact that they're in the business, in the office, in the business, late at night, potentially on their own? Do you have other people in the building? Do you have your own building? Do you have somebody at security desk? Have we thought about all of these implications? 38% people are likely now to report. So I think we're going to start seeing more and more of these reports raising. So what is going to happen from the Employment Rights Bill that is going to make changes in 2025? It's going to make us take all reasonable steps to prevent sexual harassment, but not just sexual harassment. It's going to apply to all types of harassment, which I absolutely think is fair. I mean, why should a woman be able to bring a claim where somebody with a disability can't? So it's going to be the case that any kind of harassment will give rise to an obligation for the employer to take all reasonable steps and compensation if the employer doesn't do it. So what's your analysis of what's reasonable for you to do in your business is going to become even more important, because given your size, your resources, your claims history, you have now got to take all reasonable steps once this becomes law. That's why that checklist of all the things that you're doing is really, really important. You're also going to be liable for third parties, which comes to your question. And we're going to talk about that in a sec. Anybody of that 38% that we saw on the last slide who speaks up and says, Melanie behaved inappropriately at that meeting. She was winking at a client. She was doing all these things. It was just so inappropriate. If we then take action against the complainant, they will be able to say, I blew the whistle. And that's important because anybody who blows the whistle doesn't need 2 years to bring an unfair dismissal claim. There's no cap on the unfair dismissal claim. They can bring a claim for interim relief. They can ask for money up front from you. And also, it's extremely bad publicity. So all round, the Employment Rights Act is building on this area. We're seeing a rollback in the US on EDI. What we're seeing in the UK is a double down.
What is the most effective way to handle sexual harassment complaints when the alleged perpetrator is a client or external party?
What I would be suggesting, ideal world, we will have trained our staff on how to intervene. We will have trained our staff to politely, professionally say, I'm sorry, I caught that. Could I just ask you to, let's conduct the meeting professionally and ask the colleague if they're happy to proceed or whether they'd like to step out. In trainings that we do, we tend to do a lot of role playing so that people feel comfortable doing that because it feels alien. I don't know if it's a particular Britishness, but we don't like to confront clients. So I think what we need to do is have in our policy ways of doing things, examples of polite phrasing that you get people to rehearse, that you talk to them about using, that it's a completely appropriate thing for them to do to intervene. I think sometimes if a member of staff sits there, has spotted it, but does nothing, they will then get a complaint against them for not having spoken up. So I think it's an area where we do need to just re-educate and inform and build knowledge. But I certainly think we need to be thinking about it. And I'm going to continue that answer in a second. So work events, it's very hard to do all of these. And I'm not saying that we have to do absolutely everything. But these are the sorts of things I'd be thinking about. Send your email before the offsite. Talk to them about what's expected. We're going to be in a different space. Please respect the people that you're working with, respect the people that we're going to meet. Remind them, if you do, we have a zero tolerance to harassment and discrimination. It might well be in your disciplinary policy that this is a gross misconduct offence. Do you highlight that? Possibly talk to your stakeholders, get them to be really on it, particularly for the first few things after this law has come in, so that they are really modelling what's expected. And also, if you have anybody who is not likely to model, that you've made it clear what they're expected to model. Update your policy. We've talked about that. Assessing risk. Where you're going might have a big impact on risk. If we're thinking on the venue, if you're taking people to a hotel, that might have different implications than taking somebody to a bar. If you're taking them to a well-lit field auditorium where you're now going to all listen to the proms, that might be a very different proposition from going to a hole in the wall for a quiet drink and something else. So, we've got to think about the venue and things that spaces which have good lighting, good open spaces, and ideally good CCTV. Limit alcohol consumption if you can. We see clients that are moving towards more alcohol-free beers, at least having that as an option. Also looking at signposting ways to complain so that people feel that this is a serious issue for you. Dealing effectively with complaints. Just a word on this. We've had a number of policies which come through to us to say, can you amend this for us? And they say, we'll treat every complaint confidentially. Now, that's a risky one for you. How do you treat it confidentially when you've got to speak to the alleged perpetrator and say, we've had this complaint about your behaviour, we need to talk to you about it? Some areas of sexual assault are also criminal offences. You don't have an obligation to go to the police, but if the police come to you and say, what evidence have you got? How do you then comply with that duty of confidentiality? So you need to be thinking this through. And call me because I've done a few of these myself. Not the sexual harassment I just had. How do we prevent? So coming back to this lady's question, think about your public spaces. We used to have the old notice board where we would put up, this is our health and safety policy and our ELI certificate. Let's put up some notices that say, this is how we feel about sexual harassment or any harassment. Some businesses feel that that changes the professional atmosphere. So I can understand the considerations. Let's think about some wording that we could adopt that would be aligned with your values, that would say, this is how we are as a business. Pre-recorded messages on your phone system. We are trying in businesses to have professional relationships. So we ask that people who call us deal with us professionally. Make sure that you're thinking about contracts. So if you have providers, cleaners, if you have individuals that are coming regularly into your business, ask them, what are they doing so that their staff are trained on the fact they shouldn't be harassing? That's a great one to put in your defense, isn't it? We asked this contractor, they provided us with their sexual harassment policy. They told us that they do training annually. We've relied on that assurance. You've checked it, you've risk assessed it. Signpost where to get support. So again, if somebody has received that behaviour from somebody coming into the business, it's usually the similar policy that they're going to follow. And then report and encourage others. The main things are that we've seen to take this seriously. As a business, I think sometimes people have felt that they can't report because it won't be taken seriously or they will face repercussions. And I think that the legislation is saying this is such a big issue, it's such a hidden issue, that when the select committee were looking at this, the number of people that were coming forward to say we have had serious sexual assaults and our employers didn't act appropriately. They didn't look at OH, they didn't look at supporting me. They supported and protected the revenue generator, the rainmaker, the whoever. And that has been hugely problematic. You'll have seen some of the big names that have had this come out in relation to their businesses. It's the last thing you want coming out in relation to yours. Take disciplinary action if necessary. So you investigate the alleged harassment. You look at the findings of that investigation. If there's grounds for taking further action, you start the disciplinary process. And then act on the third party. Take it up with whoever your contact is at the third party, and say to them, we need you to take steps about this. What I'm also seeing is, I don't know if you have contracts with your third parties that say you will comply with the law, or the current laws, and it's usually quite a broad clause, but it usually says things like data protection. I would certainly be adding this prevention of sexual harassment in, or prevention of harassment, I would probably put it out. If any of you do work with public authorities, they are putting it in their contracts, so you could crib it.
How should I handle confidentiality when an employee reports harassment but refuses to disclose the perpetrator's identity?
Okay, if you get that, you could, what I would be doing, I would say to them, unless I've got more information, I can't take any steps about that. Do you want to have a think about whether you can tell me more so I can look into it? And I would say to them, do you want to ask the person that's received that behaviour if they want to come and talk to me?
When drafting policies, it seems counterproductive to include an option for confidential reporting if it limits my ability to take meaningful action.
No, I don't want it. I wouldn't want you to put confidential reporting. What I would say is, I see lots of policies where it says you can report to us confidentially or we will keep it confidential. I don't think you can make that promise.
Much of the advice I've read online seems to support including a confidentiality clause in reporting policies.
Yes, I don't think that's very practical. I mean, I've had employers where we've had to provide information to the police. That's a statutory obligation. We had to comply with it anyway. But if you're in that situation, you can't promise the employee confidentiality. What you can say is we will keep it as confidential as possible. We will keep it on a need to know.
If multiple people start complaining about somebody, let's call her Sarah, then someone needs to have a word with Sarah. But if someone reports something serious and insists it goes no further, I'm really stuck.
No, you're not, because you keep the file note and you make it clear that you gave them the options and they chose not to do anything about it. I just want to pick up on something you said about Sarah. I absolutely agree that if we have got a number of complainants, we need to think about Sarah. But Sarah is our employee too. Yeah. So you also have duties of confidentiality to Sarah. You have other good faith duties to Sarah. So we have to be really careful, which is why, what I typically see is somebody's reported to us that they've been bullied by Sarah. Okay, well, what was the behaviour? When was the behaviour? What was the circumstances? There's often a bit more to the story. There's a context about what's happening. And I think we need to be really careful. If we're going to look at what is potential behaviour by Sarah that's inappropriate, we need to know the whys, don't we? We need to know, is she saying to somebody, you didn't do this piece of work to the standard we require? Or is she saying to somebody, you're dreadful, hideous, I don't know what. So I think we have to be really careful, because you are the tightrope walkers in this respect, because you are trying to balance the rights of different people. And the other place where I've seen this happen is where we had a lot of individuals who weren't happy with their line manager. So they went to HR and said, we've got all these issues with our line manager. But a lot of the issues seemed, on investigation, to relate to things that were minor but were really being overemphasized because they didn't like the new manager. And I think we have to be quite careful about taking a position when we don't have the full facts. And that's why you have to ask, if you want me to take this forward, I will need more information so that I can investigate.
What can I do about Sarah if multiple people make confidential complaints but won't take them further?
I think right now, you can probably be a little lighter on Sarah than you can be once the law changes to make sure that you've taken all reasonable steps. If we know that a number of people have raised concerns about Sarah, whilst we have to follow due process regarding Sarah, there is a question mark about whether they pose a risk. So I think once the legislation changes, we possibly have to shift it up a gear and try to get more information so that you can have that conversation with Sarah. It comes back to a lot of the labelling that we used. I've been harassed, intimidated. What were the words used? What was the tone used? What was the communication style of this individual? Is that sort of thing appropriate? There's a lot to unpack. And if you don't have that, it's really tricky. I'm not saying it's an easy one to judge. I do feel that we have to give people a right to reply if we can. But if somebody doesn't want to take it further, you can't take it further vis-a-vis an investigation. But equally, if we've got to prevent sexual harassment, we need to make sure Sarah is on the next round of EDI training. We need to make sure Sarah is aware and has signed up to your conduct policy. You need to make sure that you're monitoring Sarah so that there is no further recurrence, and it's a really tricky one. At this point, we don't have any case law to say what is reasonable steps. It's all so new. But if you sign up for my newsletter, when I get those details, I will pass them on. Just pass me your email address. Okay, flexible working. The last bit I want to talk about is a deeper dive on flexible working, because we know that this changes. And what I have is a slide with the old and new. So some things are staying the same. The right to qualify, still going to be 26 weeks. At the moment, many people talk about it still becoming a day one right. We're not certain that it will be a day one right. More importantly, it is not a right to work flexibly. It's a right to request to work flexibly. So the Beeb headline, which unnerves me every time I see it, it's not a right to flexible working. And to your point, it might be worth informing staff, talking about it in your newsletters. If anybody wants to request, then let us know, but reinforcing what the real position is. The number of requests people can make is going up. In reality, I don't think people were making that many changes anyway, but we will now be able to have 2 requests a year. What will change is how quickly you need to get that resolved. So it's coming down from 3 months, which we thought was tight, to 2 months. And in that period, we need to have met with the individual, consulted with them. We need to have put our reasons in writing. We need to have explained it to them. We need to have considered a trial period, not by law, but in practice, we're probably looking at trial periods. We need to be thinking about an appeal. If they appeal, we've got to get it all done in 2 months. So if somebody's putting the request in, I'm going on sabbatical for 5 weeks and I can't possibly deal with this, is not going to cut it. We've got to get managers looking at this more seriously quickly. Employee has to be consulted now. Previously, if we were going to say yes, we didn't have to even consult, so we could just say yes. Now we've actually got to meet people, keep records, make sure that you're showing that you've done the right things. Also, we previously had the right to say no for 8 business reasons. We still have those 8 business reasons. I'm coming on to them. But what we have to add additionally is why that reason is reasonable. So one of the reasons is we won't have work at the particular time when the individual wants to work. So if they want to work at 7:30 in the morning, but your clients aren't going to necessarily want to meet with them at 7:30 in the morning, you could have previously said, we don't have work at that time. Now we have to explain that the clients aren't available at 7:30 in the morning. We don't have the resource to support work and allocate work for the 7:30 in the morning slot. We need to show how it is reasonable that that reason is why we're declining. It sounds like a bit of mental gymnastics. I think it's just giving fuller picture to the staff member and not using the 8 reasons that we had, which we blandly put on letters before. It's a right of the employee to request flexible working, as I've said. These are our 8 statutory reasons to refuse. We have nothing that says that these are going to change. So you will still be able to say, we can't accommodate because. So it was never a right to get the flexible working. I'm going to mention this slide again. You've seen it in one context already. But just think about the overlap between flexible working requests and the risk of discrimination claims. An employee whose request is rejected might feel that they've been treated less favourably because of a protected characteristic, their gender, their disability, their race, their age. A couple of examples. What about a woman returning from mat leave? She requests the modification in working hours so she can do nursery pickup times. The business requires employees to work full-time, which could disadvantage women who statistically bear greater childcare responsibilities. So that is an indirect form of sex discrimination. It's not unlawful. It's not going to cause you a problem if you can justify it. But it can overlap if we've been heavy-handed with that flexible working application and taken the view, oh no, we can't accommodate it because we have to have everybody in the office. A very famous estate agency recently had this case where they didn't allow their member of staff 30 minutes early leave to pick up from childcare. They were found to have sexually discriminated indirectly. So, disabled employees who seek reasonable adjustments to alleviate the symptoms of their disability, might be to travel outside rush hour, get more working from home. They might put in that flexible working request. They might need, medical appointments, things like that. Again, that could be a situation where you are erring on the side of being more flexible, because otherwise the individual will say, you're discriminating against me because of my disability, and you're failing to make reasonable adjustments because of my disability. Double whammy. So just some tips. Explore the request if you can. Try to look at a compromise if you can. I think the idea of blanket, this is what we do, is not going to wash. I don't think it ever did, but I think few employees ever took the point. Look at trial periods. It's not in the law, but it's a very practical way of testing it. And you can look at whether you're satisfied. They can look at whether they're satisfied. Be consistent. On this, we've had a number of inquiries about flexible working requests where they come in one after the other in a team. You deal with the first one, you consider the first one, you decide the first one. If you get a second request in the team, you can be consistent to a degree, but you now know that one person may have got that flexible working. So you then deal with that second person according to the fact that that one first person has had the change. You follow me? If you get a third one, you then have to know that you've dealt with 1 and 2, and that's resulted in changes. So you can't be identically consistent you can't say, well, all of you can go home at 4:30, because one of you might need to be present at 4:30 because you've just modified the first two. So that's the caveat to consistency. A flexible working policy, great for managers. Then they know what's your position, what's the process they need to follow, when they escalate to you, what meetings they need to have, what time limit they have to stick to. And it also saves you repeating it. Keep records, look at your decisions, and also consider that risk of discrimination claims. That's everything I had. Any questions on part 3?
In a small team, if 2 people are granted flexible working but a third is denied, could they claim inconsistency in the decision?
They can absolutely say it. They can't necessarily prove it. Because what you can say is, well, this is the team structure now. Yeah. These are the working arrangements now. I've looked at whether I can accommodate your request now. Okay. But I think that's where the value of a meeting comes in. Yeah. Because it gives you the opportunity to actually sit and analyse with them what it means and what the position is. Yeah. So you're not just saying, no, I'm sorry, I can't. You're explaining the context in which you're having to think about this. And the other thing that might be possible in that situation is to say to them, okay, well, we can't do that, but we could do something different. Or we could, particularly if you've got 3 at the same time, you might be able to say, well, we could perhaps work a rota. Would you be willing amongst yourselves? And I've seen this with exec assistants work really, really well. The way that they've done it is that between the 3 execs, what they do, exec assistants, they actually work it out so that there's always somebody on the late night. Yeah. There's always somebody who covers, but they alternate who does it.
Could our informal 1 day a week flexible working policy now be seen as contractual, since it's become embedded over time?
If we haven't put it in and it's something we've historically followed, then it potentially becomes custom and practice and an implied term of contract. But if we haven't consistently followed it, it's something that is so occasional that it's very rarely going to come up, then I think you could probably say it's not our custom and practice yet. Most policies say on them, this is a policy. And it often says, this is a policy, we reserve the right to change it from time to time. So if in any doubt, when you're writing policies, pop that sort of language on so that you get the ability to keep coming back and modify without having to consult staff and get agreement. Okay. I think I've hopefully answered all of your questions, but if there's any more, please do reach out. It's been an absolute pleasure. Thank you for coming. I look forward to working with you. And please do let me have your email addresses if you would like the CEST or the newsletter. Merci.